Yes. Good morning.
Hi.
May it please the court, my name is David Falstad, representing appellant Joseph Fry. I would like to reserve 5 minutes for rebuttal. And this is, of course, a criminal case. Mr. Fry was convicted of burglary and sexual battery, and the appeal concerns the issue of his competency. He was, in fact, adjudicated incompetent, and then there was a report from a doctor subsequently indicating that he had been restored to competency. And then nothing was done. It appears from looking at the various hearings after that, nothing was done to address his competency with the court. There were references among the attorneys that there were evaluations taking place and people talking to experts, so it looks like there might have been a lot of activity off the record. But the point of the appeal is that once he was adjudicated incompetent, he could not be considered restored to competency without a hearing and a written order of the trial court finding him competent. Now, since a person who is incompetent, and because in this case he's been adjudicated incompetent, cannot waive the requirement of a hearing and a finding by the trial court. So even though everybody just let the subject drop, candidly, probably because he seemed competent, everybody let the subject drop, that's not a waiver, because it can't be waived. The incompetent, once he's adjudicated incompetent, he could not waive that requirement. So I believe it's something of a bright line principle here that it does have to be remanded for a hearing and determination of competence. The less clear issue or sub-issue here is whether it needs to be, should be just, well, whether the competency can be retrospectively determined nunc-pro-tunc back to when he was tried in December of 2012.
Are you asking that as at least a preliminary step, the trial court make a determination as to whether or not there could be a retrospective competency evaluation? Is that what you're asking?
The trial court make a determination?
That the trial court would make a preliminary determination as to whether he was competent at the time of trial, and if the trial court cannot make such a determination, then he'd have to be retried?
No, I'm asking for reversal of the conviction and remand for a new trial. Now,
And before the new trial could go forward, there would have to be another competency hearing to determine whether he's competent.
Yes, Your Honor.
So you're not asking for that intermediary step for a determination as to whether there could be a retrospective competency determination? You're not asking for that?
I am not, no. Of course, the option is there for the...
Does this case lend itself perfectly to that?
Well, there are indications that it would lend itself to that.
You yourself said a moment ago he candidly seemed competent.
Yes, and as far as I can tell, he did. I know that there, as I referenced, there was activity. They consulted experts, had him evaluated, so there's one might say some ambiguity and actually some suggestion that perhaps there is significant information gathered about his competence. Really, I'm asking for reversal for new trial outright, really as an advocate for my client, trying to get as much as I can for my client. But yes, there are circumstances that would indicate that it's something to be at least explored at the trial level. I'm thinking two considerations I had thought of for why a new trial would perhaps be more appropriate than a nunc-pro-tunc determination of competence is the length of trial, the length of time that's elapsed since the trial in December 2012. That somewhat works against a retrospective determination. And further, just the larger due process considerations. I think as we've discussed in our briefs, the courts have been more reluctant to, well, the courts have been somewhat reluctant to approve retrospective competency determinations in general. You know, the Florida Supreme Court has said generally it can't be done, but they've certainly made clear it can in some cases be done. But it seems that there hasn't been a lot of discussion in Florida case law, but it seems there's more reluctance to allow for a retrospective determination in a case such as this, where he actually has been found to be incompetent. So he was legally speaking incompetent. The courts are less inclined to authorize that. So considerations for simply remand for a new trial would be the importance of this due process consideration and the fact that it arguably looms larger where he's been adjudicated incompetent. And the courts, I believe, would want to avoid letting the exception swallow the rule to where it would be a routine practice to remand for retrospective determination rather than a new trial. It seems that they tend to remand for a new trial without a lot of discussion of whether it could have been retrospectively determined. And so I would suggest there's what you might call sort of a prophylactic concern or measure that retrospective determinations are disfavored in these cases, and more so when there's been an adjudication of incompetency. So those are the considerations that came to my mind on this. I don't really have anything else to offer for argument at this time.
Okay, you'll come back and see us in a few minutes.
All right, yes, thank you.
May it please the court, Wendy Buffington on behalf of the state, appellee in the instant case. The state agrees there was error in this case, and the determination this court is going to have to make is what is the remedy for that error. On the one hand, there's waiver, and the state did set out the case law trying to find out how the case has come up with waiver in this area of competency and where our case might fit in. We are not asking for that. On the other end is the vacation of the conviction and remand for a new trial, and in between is the nunc-pro-tunc. Am I too loud? Is that what's happening?
It's not. We call it nunc-pro-tunc, but it's not technically what it is. It would be a determination now whether he was competent then.
Correct, which I...
The nunc-pro-tunc would be like they had the hearing and forgot to enter the order. But this is really a new determination that he was competent then.
Absolutely. This is a determination
I
because...
think a better term is probably retrospective.
Yeah.
Retrospective.
Thank you, Judge Black.
I thank you too, Judge Black.
After the fact might be one.
After
Yes.
the fact.
After.
Whatever it is a remedy that is approved by the Florida Supreme Court. It's set out clearly in the case of U.S. v. Hudson, where it distinguishes between procedural due process and substantive due process.
This is a pretty common practice in the federal courts.
Yes. Yes, absolutely. And the first step is, as you had mentioned, Judge Black, regarding the trial court making the determination, can we make this determination after the fact? Now, right now, we are less time out from trial than trial was from the incompetency determination.
Which is also a matter of concern. You know, it's all, actually, it was a long time between the report from the facility that he had regained his competency to
Right.
the trial. That was a very long delay as well, was it not?
Yes, that was the report. That was 2 years and 4 months from that determination. And clearly, let's pretend for a moment that there had been the actual finding after that was supposed to happen on September 21st, which that 3 lines that was set for a competency hearing September 21st. We know it didn't happen. Defense says, Mr. Fry is back from the state hospital. We're participating in discovery. Let's set this out for 60 days. So that led the parties into error. They all just dropped the ball at that point. That's when the hearing should have happened. But let's pretend that it did happen. He had been determined then legally competent. That could have changed at any point in that 2 years leading up to trial. And if it had changed, there would have been the requirement for a new proceeding and determination. And nothing in this record indicates there was anything to indicate that he was in any way incompetent. You have 2 defense attorneys, not including the defense attorneys who were previously on this case and dealt with him and then did not represent him at trial. You had 2 prosecutors and you had a judge. So we would have to presume that all those people interacting with him on these regular, over the 2 years disposition hearings, ignored any signs of incompetence. So, and that is important because the case law, we have the procedural due process, which is set out in our rule, and it comes down from Pate, and that is in place to ensure that an actually incompetent person, and that is not my personal term of art, that is the term used in the case law, that an actually incompetent person is not brought to trial, that the power of the state is not brought against a defenseless person. And that process was implemented in this case. We don't know why. Presumably, defense counsel asked for an evaluation, but 2 doctors were appointed. They both evaluated him. The first doctor evaluated him on May 11th, 2010. This is about 8 months after he's arrested. And that doctor, 15-minute examination, defendant would not cooperate any further. And that doctor, Dr. Taylor, said, I cannot say, based on this examination, that he is actually competent. So, I recommend sending him off for commitment. A short time, 1 to 3 months, we'll know whether he's malingering or whether there's a psychotic disorder. The second doctor clearly found him incompetent. So based on that, so this is showing procedural due process was activated to protect this defendant who was incompetent at that time. He's sent off to the hospital, he's treated, and there's a report that he's restored. At that point, the system broke down as far as the procedure, but the procedure is there only to protect an actually incompetent defendant. And there's nothing in here. In that 2 years, we'd have to presume all those 5 lawyers and the judge ignored that. We also have a transcript. We have, critically, the motion to suppress. I'm sorry, I've got this like vibrato in my voice. I wish it would go away. But anyway, we have the motion to suppress confession hearing. That's 1 month before trial. And what do we see there? We see the defendant who actually, there's a break where the defense counsel is questioning the detective and he confers with his client. And based on that conference, he then goes back and asks the detective, isn't it true that after the defendant was arrested, you found this pill in the back seat of the cruiser? And the detective says yes. And then, isn't it true that Mr. Fry said to you that that pill was needed for him to maintain his mental health? And the detective, I don't remember that part. So that showed that the defendant was actually conferring, giving factual information for his attorney to act in his best interest. And also at that hearing, there is conference over exhibits, like 1A, B, and C. And this is in the record volume 3, page 455 and 457, where the defendant, there's again a conference, and based on that conference, the defense counsel asked about 1B. He didn't understand about that. So it shows what we do have before us shows us that he was able to participate in his defense. We have the cogent testimony at sentencing where he apologizes, accepts responsibility for what he did. So,
of course, he says he doesn't really remember everything he did.
Yes, he does. Which all went to why there was this 2-year delay, right? Why was that long delay? Because the defense was investigating a not guilty by reason of insanity defense. Admittedly, the only defense you can imagine, where you have a confession, you have this DNA evidence, you have the property of the victim recovered on defendant's person when he's arrested, in the motel room when he's arrested. You have this third piece of property submitted by an acquaintance, the defendant gave me this. So it was a defenseless case, here. And so
He did not testify.
he did not testify, no. And there's a brief waiver.
Did the defense put on any case at all?
No, they did not. It was, challenging the best they could do.
Confession, DNA, verdict.
Pardon me?
Confession, DNA, verdict.
Yes, and the stolen property and the victim identifying him in court at that point. So it was a very difficult case for the defense, and they seemingly worked very hard to pursue the avenue that they had, which was a mental health defense. So we know by this record that going back, it's not like a case where the procedural due process was not invoked and we would just be, grasping at straws with no evidence. But this record indicates that it's a perfect case to go back and that there is the evidence with his examinations, which the record indicates that Dr. Taylor, we don't know if it's the same Dr. Taylor, was examining him at the time of trial, while they were pursuing what mental health defense that they had.
Ms. Bevington, though, I hear what you're saying, and it's all accurate. I have a concern, though, about sort of the ad hoc nature of these cases where, is the remedy that we should should opt for, dependent on whether we can find any suggestion in the record of whether he was competent or incompetent?
Yes, actually, yes.
Yeah, but that, you know, as I say, we have a procedure for the trial court to make factual determinations of
Right.
this stuff, and whether and when that procedure is followed, you know, everything's hunky-dory, and when it's not, then now we're supposed to do a record review to decide, well, gee, you know, in our view, looking at this cold record and not being privy to all the off-the-record discussions there seems to be in this record, contrary to the rule of criminal procedure, that, you know, well, he seemed competent, or he didn't seem competent, or here's a red flag. I mean, you know, and I'm not suggesting that the ultimate result here wouldn't be to the state's liking, but how do you articulate the rule other than we're supposed to, on an ad hoc basis, make our own appellate determination whether he seemed competent or not?
No, and so I certainly hope that my argument doesn't suggest that you are making that determination, but you are looking at a record to see whether or not there was a substantive due process violation, and that is the only case where you need to have it reversed, or if you didn't have any procedural due process activated. So of course we have no idea. One of the cases says,
Well,
you know.
I mean, if the procedural due process was activated, but it wasn't completed, you would acknowledge that's a violation of the procedural due process.
Yes, it's a violation where we have this gap, and we're asking just to go back in and fill in that gap, if it can be done. And
Well,
certainly,
as I understand it, you're not asking us to make a competency determination.
Of course not.
You're asking us to send it back to see whether the experts can or cannot make a reconstruct
Right.
it. And if they
Right.
can't,
it's a new
it's
trial.
a new trial.
It
Right.
would seem to me that that would be the only really avenue available to us, other than just reversing the conviction, as counsel says. But it would seem to me that that would be the only available avenue to us in every case where that was the process was not completed, unless we're going to find facts based on the record.
Yes. So I'm not sure that I'm understanding your question, Your Honor. Are you saying that the remedy is always?
I don't know how we can certainly see things in the record that suggest something, but I don't know how we can make a determination whether there was a violation of
Substantive?
substantive or procedural, one or the other. Because
Well,
we're not a fact-finding court, we weren't there. All we can do is look at the record, and I suggest that if the, you know, possibly if the experts say, A, they can't reconstruct, then that procedural failure has to result in a new trial. Or they come back and they say, you know, yeah, we can reconstruct, he was not competent. And now
Right.
they have, by their testimony, demonstrated a substantive due process violation.
Yes.
But we can't make that determination.
No, I'm not asking you to do that, but I am trying to sort out, like, there are cases that do not remand for a retrospective competency determination.
It's apparent on the record.
Because it is apparent on the record, right?
I think we could find that it was perhaps apparent on the record that he was not competent, but I don't know if we can find that it's apparent on the record that he was.
Oh, no, we can't, because that is blending the procedural due process and the substantive due process issues to entertain the fact, okay, yes, only the trial court can make that determination of competency. It's not a medical determination, it's a legal determination, right? And I understand what you're saying. Is that what you're saying based on the fact that this record shows we have a legal incompetency in June 2010?
Right, and we're kind of stuck with that until shown otherwise, and we haven't been shown otherwise. We've got a record that suggests probably
Strongly.
otherwise, but we, you know, we can't actually make that determination.
Well, if that was the case, Your Honor, then there would be no remands for this kind of a hearing.
Well, I'm not sure. I think actually it would weigh in favor of a remand in every case. That if you don't get it done before the trial, you're going to have to come back and consider this again. And I would personally be far more comfortable with that kind of bright line rule rather than have appellate judges looking at a cold record trying to decide, did he seem crazy or not? What was the tone of his voice? We
are fortunate in this case that we did have some procedural due process there, and then we had the lapse. We didn't go to the end of the game.
Right.
the cases where there isn't procedural due process afforded, those cases get reversed because you don't have any protection, and it's speculation at that point. It is appealing that there is a legal finding of incompetency, to take that and just say that he was then tried while incompetent, which is the reason that we are here today to clarify that that is not the end result in this trial, and that there is precedent for remanding for this retrospective determination, even after that legal finding of incompetency, where he has not been restored legally to competency.
Okay, let me ask you this. We talk about remand, and we do. Are you talking about a relinquishment during this appeal, or are you talking about a remand after this appeal? And then what happens on that remand?
The cases that are remanding, including Bell from this court in 1975, they do not use the term relinquished jurisdiction.
Because the problem is that we can't really affirm a conviction without the factual foundation that would be established in the hearing.
I do understand that, and that was a flaw in the state's prayer for relief, asking for affirmance for this remand.
Right, well, yeah, but I mean, but what do? We don't reverse the conviction, do we?
No. One of the cases, and I believe it was this court's case in Bell, remands and just says, with directions to hold the hearing if it can be done, make a finding whether it can be done, and then to go ahead and hold the hearing. And it says if it is determined that he is incompetent, to grant a new trial. And if it
Set aside the conviction and grant a new trial.
Yes, and if it's determined he's competent, to just send it back up. So this court is going to review it either way. But the one case was remanded, so ordered. So it didn't say reversed or remanded. SB, a recent case from the 4th District, 2014, just a couple months ago. They affirm in part, reverse in part, and remand.
Okay.
Everyone's happy that way. So that is the state's request in this case, that this court remands with directions for the trial court to determine whether or not it can hold this retrospective hearing, whether or not the tools are available to ensure that the defendant's substantive due process rights are protected, and if so, to hold that hearing, and then to send up the written order and the transcripts back to this court where it can be reviewed for whether there's substantial competent evidence to sustain the trial court's order, whatever it finds. Thank you very
Ms.
much.
Buffington.
Well, I would note that the state appeared in the briefing to draw some distinction between someone who's legally, on the one hand, legally incompetent because he was adjudicated incompetent, then on the other hand, someone who's actually incompetent, and suggesting that the court should look at whether someone was possibly not really incompetent, even though he was earlier been adjudicated incompetent. And I would maintain that there really is no such distinction in the case law, that the court has to, in a case like this, he has to be regarded as having been actually incompetent from the time that he was adjudicated incompetent. And there, of course, as we've been discussing, there is the suggestion that even that could potentially, in some cases, be retrospectively determined. But without that hearing and finding by the trial court, he has to be regarded as incompetent, as an established fact. What else? And it does not seem to be an especially common practice in general to remand for a retrospective hearing versus just reversal of the conviction. But again, it seems like in the case law, convictions were often reversed without really a discussion of whether anything could be retrospectively determined regarding competence. But I would note again that the Florida Supreme Court has noted that it's generally cannot be done, it's disfavored. And I would suggest it's even more disfavored when someone is regarded as actually incompetent because he was adjudicated incompetent. So there's really no place for a waiver analysis here because someone who's been adjudicated incompetent cannot then waive the issue. And
Well, and I think that, although the argument is made in the state's brief about a waiver, I think that the remedies there I've asserted suggest that there is no waiver. The question is, what is a remedy?
yes. Yes, I would agree. Let's see, if the court has no further questions, I have no further argument to offer.
Thank you, Mr. Falsey.
All right, thank you.
Both. The next case is Bridgeport South Realty Advisors versus CVS Pharmacy.